Right. Hello and welcome to the Law Lab. Here we dissect and unpack everything legal. My name remains Aaron Asidwentri, and as usual, your favorite host. We have been looking at public international law with esteemed guest Ben Mahmoud Adamu, where he runs through what public international law is. In that same video, we were able to ascertain whether public international law is a law. We moved ahead in the next episode after that video episode I'm talking about to appreciate whether or the sources of international law. Today, in the last episode, we were able to espouse about 4 sources of international law, as in having it through our ICJ Statute Article 38, Clause 1, where paragraph A, B, C, and D gave us the sources of public international law, or international law if we are simply putting it. And so A talks about treaties, paragraph B talks about customary international laws, paragraph C talks about general laws or general principles of laws recognized by civilized states, and the last one was judicial decisions or publications by highly qualified publicists. Just for humor purposes, we mentioned my classmate Divine Salu, which we call him the IGP, Inspector General of Petitions. And I said that the ICJ should consider his petitions as some source of international law, because that guy can petition.
Yeah.
You know, he just walks around with about 38 petitions
In his pocket.
He just scan the environment and see that all these 38 circumstances might happen. And so he has all the petitions. All he has to do is to address
When it happens, he pulls one out.
when necessary.
Yeah.
Today, we want to look at solely Article 38, Clause 1, Paragraph A. That is treaties. And delve much into treaties to understand what treaties are and also even the legal effect of it. So, Ben, when we talk of treaties, what are treaties?
Thank you very much, Aaron. And before we get into the matter proper, I'd want to thank you for giving me another opportunity to speak with our esteemed viewers and try to, like you put it, break down the law into small bits that everybody will understand.
Sure.
Thank you very much. Today, for our discussions, we'll be looking at treaties, like you mentioned. The primary reading material for anything that concerns treaties would be the Vienna Convention on the Law of Treaties. And so, throughout all of this discussion, we would be mentioning a lot the Vienna Convention on the Law of Treaties. Now, Article 2 of the Vienna Convention of the Law of Treaties is the definition article, where all the terms that are used in that convention are defined. All right.
So for the please hold on. For the purpose of education, anytime you pick any act or law which is codified, mostly we have the definition section. Yeah. So when you pick our Constitution 1992, Article 295 serves as the definition section, which talks about all the necessary terminologies in the Constitution. So clearly, as he mentioned, Article 2 is serving as the definition section for what treaties are in the Vienna Convention on the Law of Treaties. I think you can simplify it as VCLT.
Absolutely.
Sure.
So going forward in our conversation, I would be referring to that as the VCLT. Mm-hmm. Now, Article 2 of the VCLT, as we've established now, defines a treaty to mean an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in 2 or more related instruments, and whatever its particular designation. I think when you hear this definition of what a treaty is, it's more complicated. It brings out a lot more questions than we had before referring to this Article 2. And I'm sure that subsequently, when we go on to further into this discussion, we will take the elements as have been presented in the definition one by one. I
think we should be breaking it down and so that you explain it.
Right.
You rightly mentioned that treaty means what?
An international agreement concluded between states. So that is the first
bit of it.
Elements that we are going to establish, that for a treaty to be a treaty, so-called, which can then be governed by international law, it must necessarily be between 2 states or two or more or two or more party states must be. An example of a treaty, for example, is the UN Charter, as we all know, where in our first video, I think we mentioned that there are about 190 or so party states to the UN Charter. All right, over that. Right. So the first component is that it is an agreement which is entered into between nation states, all right, as the parties to that agreement.
That gives it the international look.
Exactly. Sure. Like we saw in the first video, public international law had to do with party states, Right. The second thing that we must be mindful of is that a treaty must be in a written form. Okay. All right. It must be in a written form. But it goes on to say that it does not matter whether it is embodied in a single instrument
or let's stay on the written
or more.
Let's stay on the written form. When you pick the contract at, I think either Article 11, Section 11 at 25 is what I'm talking about. Forgotten the specific act section. It says that a contract can be either written, oral, or both. Yeah. So is it the case that with regards to treaties, it should specifically be in a written form?
Yes. The only requirement for what a treaty should be is that it must be written. All right. However, it does not tell us or prescribe any particular format for the writing. All right. So there isn't a format that has to be followed specifically or anything of the sort. What the VCLT in Article 2 requires of a treaty is that it must be written, or it must be in written form. All right. And then the last but not the least is that it doesn't matter what we call it. There are several names that, other terminologies that
I think what you are missing out is that it shouldn't necessarily be in one instrument.
Exactly, yes. I mentioned that briefly, that it doesn't matter if it is one instrument or two or more instruments that make up the treaty. Now, when we say an instrument in law, we are referring to a document which spells out the terms of any agreement, right? So when Article 2 of the VCLT mentions that it does not matter whether it is in a single document or in two or in multiple documents, it is really saying that a single sheet of paper can constitute a treaty. Okay. It is saying that one bound pieces of or several bound pieces of documents in one to make a book or a pamphlet could be a treaty. It could mean, or it also means that it could be several other pieces which are not together put into a single book or into a single document. But as far as all of them, when they come together, they tie party states into, they tie them in some obligations with regard to each other. Then such, several pieces of instruments could also be a treaty. Okay. All right. Now, the third thing that you must be mindful of is whatever the form or whatever the designation, you give to a treaty. Like I mentioned earlier, there are some synonyms or words that have similar meaning, and you would have noticed that I may have used international agreement a number of times whilst we are speaking. Some people choose to call it an international agreement. Some people choose to call it a convention. Some people choose to call it an international covenant. What the concluding part of Article 2 is saying is that it does not really matter what you call it. As far as the requirements of a treaty are fulfilled, that is, it ties the party states into an obligations in relation with each other. It does not really matter what you call it. It is a treaty, and it is the legal effect of those documents that the VCLT would be concerned about, and not necessarily what name has been given to it.
So I recall this case. I think it's one of the foremost cases in contract law. That is the case of P.Y. Atta and Sons versus Kinsman. And with regards to P.Y. Atta and Sons, if you would recall that it wasn't an assignment, but it was a lease, which had the nature of an assignment. And the court held that no, this is clearly a lease, because what you were engaged in was in a form of a lease agreement. If I want to even brief the case where P.Y. Atta had gained some lease from the government for a number of years and decided to give some of or part of the said lease to Kinsman. and gave them regulations that you'll be paying rent and be doing all other stuff.
Yeah.
And Kingsman now realized that, Charlie, what these people have given us, they have assigned the rest of the years to us. So clearly it's an assignment, but they were still paying the rent. And so PY quickly went to court for rectification to reduce the number of days to at least a day, so that it wouldn't be in an assignment format. Kingsman said that we feel it's an assignment and we're not going to give you any store that you are demanding. The court said that what you are engaged in is a lease, not an assignment. So clearly, the understanding or the definition of what a treaty is gives me a clearer understanding is that no matter how you would actually term it, it is when immediately is binding two or more states into some certain or some obligations or rights and obligations, then clearly that is a treaty.
Especially, and just to add to what you have said, especially when you read the commentaries on the Vienna Convention on the Law of Treaties, it speaks into detail on this requirement, as we have mentioned. It goes on to say that whether you choose to call it a covenant, whether you choose to call it a convention, or whether you choose to call it an international agreement or even a treaty, it is a matter of terminology rather than of form. All right. So it is really semantics and what your preference is. It does not necessarily change its effect as far as the legal implications of that agreement is concerned.
It as well even brings this case into mind, Banfo and another versus the Attorney General and another.
Yes.
I think that the AG, then the AG was being represented by the Deputy AG, Dr. Dominic Ayine Esquire. And he was stating that this is just a note verbal and not an agreement. And the court actually told him that Article 75 of the Constitution 1992 does not specifically mention any form of agreement.
Absolutely.
So if you have entered into an agreement, whether a note verbal, whether a proper treaty or whatsoever, that is an agreement. So the note verbal was even construed as a treaty.
Exactly.
So can you now take us through the nature of a treaty?
Right. Okay. Now, these three things that we have seen, or these three elements that we have taken out of the definition as provided for us by Article 2 of, the VCLT, would then go ahead and give us, some further discussions onto the nature of a treaty, or if you want, the characteristics of a treaty. The first one, as we said, is that a treaty must be an international agreement concluded between states, right? Now, when you take the case of the Anglo-Iranian Oil Company case, right?
The case will be on the screen.
Right. The case will be put on the bottom of the screen for those of us who are watching so that we are conversant with it. It was a case that the ICJ sat on in the year 1952, right? It was a case between a British oil company that had established itself in Iran. It went into a concession agreement with the Iranian oil company. In signing the agreement, right, representatives of the Iranian government countersigned the agreement with the British firm that had established itself, that it was entering into this concession agreement into. A dispute arose, right, and the British company ran to the ICJ asking that, they intervene or make a determination on the disputes that exist between the two of them. All right. Their argument was that because a representative of the Iranian government countersigned, it meant that agreement was an international agreement or a treaty which should be governed or regulated by the VCLT. Right. The court, in making a determination, said that the VCLT necessarily has to be between the governments and not a mere signature by a representative of the government. He said that the signature that the representative of the Iranian government appended was only to show the government's agreement or approval of the transaction or the concession that the Iranian oil company was entering into. It did not in any way tie the government of Iran and the government of the United Kingdom into any obligations relating to each other. And so for that matter, the court refused to treat that agreement as a treaty because it did not in any way amount to a relationship between the government of the UK and the government of Iran. All right?
This is quite problematic. Because I'm a representative of a government I go meet another country or a country that is being represented by its own people.
Yeah.
And I commit Ghana into an agreement, and you are saying that Ghana is
Well,
not-
but okay, so even if the Iranian representative signature is one to be construed as having tied the Iranian government into an obligation, it does not tie the Iranian government into an obligation with the UK government. Let's be mindful of the fact that public international law is law between two sovereign states, right? Or that governs relationships between two sovereign states. In this matter, even if the signature had bound the Iranian government, it did not bind the UK government. It only bound the Iranian government in respect of this British company that had established, some operations.
it's a company.
It's a company.
Okay,
It's a company.
I now
Yes.
get it clear.
So it was a British company that entered into an agreement
that is right.
with an Iranian company. But in signing the agreements, the representative of the Iranian government countersigned that agreement. And the British company tried to make that mean that the Iranian government had bound themselves.
It makes a lot of sense now.
In some relationship.
Because the company, the UK company or the British company does not represent the government of UK.
Not at all. Not at all.
I think it will even take us to get the opportunity to appreciate who can now commit a state.
Exactly. And subsequently, we'll look at that when we finish the discussions on the nature. The second thing that we must be mindful of, and we've had some previous conversations about that, is that a treaty does not necessarily have a form requirement. Apart from the fact that it has to be written, it does not have any form requirements. That is a laid down procedure to fill out a treaty.
It is not cast in stone.
Exactly. Parties are at liberty to decide how they couch or how they put together their own agreement. And this has been a matter of many, disputes, subject matter of many disputes that the ICJ has had to resolve. Case in point is the Qatar versus Bahrain case, all right? There was a bilateral meeting between these two governments that was held, and a communique was issued after the bilateral meeting, all right? Now, Bahrain failed to carry out some of the obligations in this communique, or the obligations that were provided for in the details of the communique. And Qatar had reason to go to the ICJ for the ICJ to make a determination on the matter. Now, when the matter was called, Bahrain said that, well, it was only a communique that was issued, and it was not necessarily an international agreement or a treaty. Okay, and so they cannot be bound by the communique as was issued after their discussions. And the court disagreed with Bahrain and said that exchange of letters and even minutes of meetings can form or can constitute an international agreement or a treaty. And so even a communique, as long as it binds the two states into some obligations in relations with each other, then such a communique would even constitute an international agreement.
Right.
So again, you also referred to, a Ghanaian case which gained popularity, when it was heard.
Banfo and Henry Nanabuache. I beg you. He is the incumbent NPP national
of the ruling party.
Yes. He's a lawyer too.
General.
Yes.
Right.
And I know that. This is the Attorney General.
Right. The court in that case also said that, like you mentioned earlier in this same video, what constituted the international agreement was the exchange of diplomatic notes, or what is properly called note verbal. Right. The court said, and Justice Sophia Kufu, who was the Chief Justice at the time, said something which has, which speaks to the matter that we are discussing this today. She said, the Constitution makes no mention of any formal distinctions that are dependent on the formality with which such an instrument is formatted or brought into being. From the aforementioned principles of constitutional interpretation in Ghana, there is no doubt that by various forms of documentation, the government of Ghana binds countries, the Republic of Ghana, to certain obligations in relation to another country or group of countries. An international agreement comes into existence. So the Chief Justice then, Her Ladyship Justice Sophia Ekufu,
Was she Chief Justice then?
she was.
Okay.
This matter was heard in 2017. She was Chief Justice at the time. She, in her judgment, also alluded to the fact that it does not matter what form the international agreement is put in. It does not matter how it was brought into being, as long as it is written and it binds Ghana in some relations to another country, a group of other countries, then an international agreement has come into being. So the form of the agreement does not really matter, all right? It does not have to be in a well spelled out document, or it does not have to follow any set rules. Similarly, in another Ghanaian case,
so let me just chip this in. Anytime a justice is retired, you mentioned the name, say Sophia Kufu CJ. She's retired now, so you just add as she then was. Yes. If she was, or the person was a Supreme Court judge, say, I don't want to be on the bench. Let me put that. So Mahmoud JSC, if he's retired, Mahmoud JSC as he then was. When Mahmoud was in, say he gave the judgment as a justice of the Court of Appeal, Mahmoud JA as he then was. If he's still in force or he's still working, you just leave it Mahmoud JA. And when Mahmoud is given the judgment as a High Court judge, you just say Mahmoud J. Probably Mahmoud would want to be on the bench. And we have reservation.
Well, right. Thank you very much for the addition. I was taking us to also look at another international agreement that was a subject matter of adjudication in our Supreme Court, and that is the case of Buja Jemfi versus Attorney General. Right. Now, in the case of Buja Jemfi versus the Attorney General, the government of Ghana had entered into an agreement with the United States government, all right, to establish a military base here in Ghana.
Wow.
Right.
I think in Takrady.
Yes. Right. As Article 75 of the 1992 Constitution would require, the Ministry of Defense then submitted the unsigned document to...
Please, let me give this. Buja Jemfi is the Director of Special Duties of the National Democratic Congress. Let me put that out. He's contested as national, I think he's been youth organizer for the Ashanti Regional Party of the NDC, and contested twice with Pablo. Pablo is a lawyer. Jojo Pariado as national youth organizer in 2018 and 2022. He lost on both elections, but currently I think he's the Director of Special Duties of the NDC. Just as I did for Nanabi, I don't want a problem, so you need to keep it across.
That's important. Right. Thank you very much for the addition on trying to, inform us who Buja Jemfi is in our national body politics.
Sure.
Right. So when the agreement was, the matter of that case, right, was that the government of Ghana had entered into an agreement with the United States government to establish a military base for the U.S. Army in Ghana. I think somewhere in Takrady. That also gave them some rights and privileges, for access to our main international airports, Kotoka International Airport, and so on and so forth. Now, in pursuant to Article 75 of the 1992 Constitution, the Minister of Defense then subjected the agreement to the Parliament of Ghana for ratification before it became binding on us.
I think it was an unsigned agreement.
Yes. The difficulty Buja Jemfi had was that the agreement that the Ministry of Defense submitted to Parliament had not been signed. All right. And he said that if the document had not been signed, it could not properly be said to be an international agreement. Right. And the court in that matter, in relying on the decision that was made in the Banfo versus Attorney General matter, which we have discussed earlier, the court in that matter said that if even note verbals or the mere exchange of note verbals were said to constitute an international agreement, then in the opinion of the court then, this agreement, which even though had not been signed, and mind you, note verbals are not necessarily signed anyway, then that also would constitute an international agreement which had to be ratified by Parliament. But subsequently, when we delve deeper into treaties, we'll look at how treaties gain effect and how countries can express their consent to be bound by a treaty, and juxtapose that against the decision of the court in the Bujaji versus Attorney General case, and see whether or not we agree with the court's decision in that matter.
So today we looked at the introduction of treaties.
Exactly.
And treaties must be quite bulky.
Yes. Treaties is a very bulky thing. And I think that you probably would have to invite me over again for another cup of coffee so we do the concluding parts of
It is good you
treaties.
mention coffee because I don't want any propaganda in here. Ladies and gentlemen, thank you. This has been the introduction or the introductory part of treaties. I believe you enjoyed it, and in our subsequent episode, we will be moving a step further into looking at the effect, how treaties come into force, and all other aspects of what a treaty entails. Remember, this is the Law Lab, and I've always been saying this: do not leave all your matters to God. Take some to your lawyer.